I think we're going to begin. Good afternoon and welcome to a new and fresh season of the Creative Champions Network, where we come together to share and learn and strengthen our organizations and arts in Toronto. Today, there are participants joining us from across Toronto, the GTA, and across the entire province. There are 46 treaties and other agreements that cover the territory, what is now called Ontario. We encourage you to learn about the treaties and territories in the regions you are joining us from today. I am joining this webinar from the territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat. Toronto is covered by Treaty 13 and is subject to the Dish with One Spoon Wampum Belt Covenant, who peacefully share and care for the resources around the Great Lakes. Our session today is timely. We've invited Benjamin Miller, staff lawyer from Community Legal Education Ontario, or CLEO, to help us better understand the new Ontario Nonprofit Corporation Act, or ONCA legislation, how it impacts our organizations, and what we may need to do before the deadline of October 18, 2024. Now, Benjamin's bio was previously shared with you through email, so please refer to it to learn more about Benjamin. This webinar is being recorded and will be shared with you as a resource after the session is complete. There will also be an opportunity for you to ask Benjamin questions after the presentation. If you would like to pose a question forward, please use the Q&A function at the bottom of your screen to ask the question. We likely won't be monitoring the chat because I know there's quite a few participants in the webinar today. But please introduce yourself in the chat to each other and we will begin the presentation. So I'm going to pass it over to Benjamin Miller.
Hello, everyone. It's a pleasure for me to be with you here today to talk about everybody's favorite topic, Ontario's Not-for-Profit Corporations Act, or ONCA for short. As you see, the title of my PowerPoint is ONCA's finally here. I may as well have added yay. We're going to talk about three different things. The main things that are new in Ontario's Not-for-Profit Corporations Act, the steps you may need to take to come into compliance with Ontario's Not-for-Profit Corporations Act. And at the end, we'll look at some of the free resources that CLEO provides that you may find helpful in your transition process. A bit more about CLEO. We provide plain language legal education and information in a wide variety of topics, including employment law, immigration law, family law, criminal law. You name it, we've got legal information on it. So if you, your staff, your volunteers, your clients are looking for legal information in these areas, I encourage you to check out stepstojustice.ca. I would also be remiss if I did not mention these workshops are delivered in partnership with the Ontario Nonprofit Network and are possible thanks to the generous funding of the Law Foundation of Ontario. As a lawyer, I am very fond of disclaimers. I have not one, but 4 disclaimers for you today. Disclaimer number 1. All of today is general legal information and is not tailored legal advice. That means I cannot tell you what you should be doing. That's not because I don't want to help. It's because I cannot help effectively without seeing your governing documents in front of me, without knowing the history of your organization, your culture, your values, etc. Number 2, today is a high-level overview of the ONCA. For more information on the ONCA, feel free to go to our website, sign up for newsletters, take some of our longer format workshops. But today we're just giving a kind of introductory overview. I will also note we're talking about the ONCA, and there are other areas of law that may affect your governance. For example, you may be a charity, or you may be governed by a specific act which was created just for you if you're a particularly old organization. There are other areas of law to think about, such as employment law, contract law, and so on. I will mention charities in a few places, but if I say nothing, just assume I am talking about the ONCA alone. Disclaimer number 3. Today is about law. It is not about best practices. Just because something is legal does not make it a good idea. My job is to highlight for you the options that are available for you under the law. Your job is to decide which of these options actually make sense in your case. Number 4, today is about law. It's not about your funder's expectations. I note that some of you in the pre-session survey asked about the rules around audits, audited financial statements. I'm happy to say we will be discussing audits, and there are new flexibilities for audited financial statements. These new flexibilities, however, may be more flexible than your funders are prepared to accept. That's a conversation for you to have with your funders. I know many funders, as ONCA took effect, have started to think about, do our financial reporting requirements still make sense? So that's a live conversation for many. I want to build on Michelle's land acknowledgement and ground our work today in the treaties by sharing with you and contrasting the way two kinds of treaties that apply to the land where I am, downtown Toronto, apply in practice. I think contrasting them will leave us with some fundamental lessons that we can apply in all of our governance. On the left, you may see pictured what's called a wampum belt, a dish with one spoon treaty. The way these treaties work in practice is they're brought by messengers to important meetings that are held by the different nations involved in the treaties. And the belts, so to speak through the messengers, reiterating the terms of the treaty. As the relationship grows and as year after year more meetings happen, the terms of the treaty also develop and grow with the relationship. Contrast that with the treaty pictured on the right, Treaty 13, the so-called Toronto Purchase, the first attempt at which was made in 1787. By 1805, the Lieutenant Governor of then Upper Canada was so disturbed by its questionable legality that he had his staff go look for a copy. Note, he didn't know where one was. As I've read it, the staff found a copy literally in a shed somewhere, pulled it out only to find a blank deed with signatures from other pages attached to it. That doesn't meet any standard of legality, and they proceeded to try a second version which had its own problems. Why am I telling you all this? Because very often I meet nonprofits who relate to their governing documents more like Treaty 13 than the dish with one spoon. They had a lawyer maybe write it for them one day. They filed it away, not to be pulled out for maybe 2 decades. When somebody gets nervous, only to pull it out, literally blow off the dust, maybe only to find that what we've been doing in practice all this time has nothing to do with what we've written down. Contrast that with the wampum belt. It's iterative. It's brought out on an ongoing basis at important meetings. It grows, and it's fundamentally about the underlying relationships. If you take nothing else away from today, I hope you take this. Complying with ONCA, as well as complying with any other law, complying with the treaties is not just about what we write down in our documents. It's how we take what we write down in our documents and actually integrate them into our practices. It's not a once and done thing. It's something that grows as our communities grow. And fundamentally, governance is about the underlying relationships, and we shouldn't lose sight of this. With that in mind, I want to make sure we are all on the same page. Many of you, when asked on a scale of 1 to 5, how would you rate your knowledge of ONCA? Some of you said 1, some of you said 2, some of you said 3, some of you said 4, some of you said 5. So we have a wide range of knowledge in the room today. I want to make sure we're all on the same page about certain key terms. So firstly, ONCA, Ontario's Not-for-Profit Corporations Act. What is it? ONCA is a piece of general corporate legislation. It governs things like who is a member of your organization, who is a director, How do votes happen? What records do you need to keep? Things like that. ONCA applies to provincially incorporated nonprofits, which means it does not apply to federally incorporated nonprofits. If you are incorporated under the Canada Not-for-Profit Corporations Act, it does not apply to you. You can save yourself the next hour. If you are a provincial organization, but you are not incorporated, let's say you're an unincorporated group or you're a program of a larger organization, ONCA may apply to the larger organization, but it doesn't apply to you. It does not apply to cooperative corporations under the Cooperative Corporations Act. So if that's your case, again, save yourself the next hour, it doesn't apply to you. ONCA took effect on October 19th, 2021. So it applies now, and we're going to talk later more about what that means. That's ONCA. Now talking about governing documents. From ONCA's perspective, there are 3 types of governing documents: a letters patent, bylaws, and policies. They're different, but they all relate to each other. I'm going to explain what they mean now. Number 1, your letters patent. Letters patent are now called articles. This is just a change in terminology. It does not require you to do anything about it. Articles were first sent to you when you became incorporated. The government sent it to you. It would contain important information such as the name of your organization, your founding directors, your address, your purposes as an organization, and any special provisions that you may have asked for. Often, they're very short documents, so don't worry if yours is short. Number 2, bylaws. You may call them something else. You may call them a constitution, governing rules. As Shakespeare wrote, "A rose by any other name would smell as sweet." It doesn't matter what you call it. It's about what's inside it. If it contains the rules of governance, things like what's the size of our board, when and where do we have meetings, how do we conduct votes, chances are, from ONCA's perspective, it's going to be considered your bylaws. The third type of document are policies. Nonprofits have lots of policies: HR policies, confidentiality policies, volunteer policies, codes of conduct, so on and so forth. ONCA does not have a lot to say about policies directly. So today, when I use the term governing documents, unless I say otherwise, I am referring to articles and bylaws. Shifting gear, let's talk about some key roles in your organization. From ONCA's perspective, there are 3 key roles. Number 1, your members. Number 2, your directors. And number 3, your officers. What I really want to emphasize is that although these 3 roles can all be filled by the same people, they are 3 different roles with different rules. They need to be kept separate. So number 1, your members. Members are to nonprofits as shareholders are to for-profits. In the same way that a business answers to its shareholders, a nonprofit answers to its members. Members have the ability to elect directors and remove directors. Members have the ability, or their approval is required to vote on bylaws, to approve sales of major assets, mergers, changes to purposes, and other important decisions. Members are very important. Who are your members? The answer is your members are whoever your bylaws say they are. That is the first place to look for a definition of membership. Number 2, directors. Directors, also known as the board, and sometimes unhelpfully referred to as the members of the board. I say unhelpful because members of the board and members of the organization are two different groups, even though they may be the same people. The board is responsible for the collective oversight of the nonprofit. As a group, they vote through board resolutions, usually at board meetings, and they're responsible to make sure the organization moves forward and accomplishes its mission. Directors are elected by the members. Contrast that with officers. Very often, I meet nonprofits who use the term directors and officers interchangeably. While they can be the same people, they are different roles. What are some of the differences? Remember, directors make collective decisions. They don't have individual powers. Officers, on the other hand, have individual jobs, and they have the powers they need to accomplish those individual jobs. For example, a treasurer may have powers relating to the finances. A secretary may have powers relating to the records, and so on. Remember, directors are elected by the members generally. In contrast, officers, by default, are appointed by the board. Now, you can have a structure where your directors and officers are both elected at the same time. That's fine, but if you want that structure, you have to say so in your bylaws or your articles. So why care about the ONCA? Obviously, you're here, so on some level, you must care about the ONCA. Here are 4 reasons to care about the ONCA and 2 reasons why nobody needs to lose sleep over the ONCA. Number 1, ONCA provides you an opportunity to revisit your governance. Pull out your governing documents and ask yourself, do these rules still make sense for us? Number 2, under ONCA, some new things are possible. There's new flexibility in how you do financial review, in the structure of your board and your membership, and so on. You may want to take advantage of this flexibility sooner rather than later. Number 3, your funders may ask you, have you complied with the ONCA? This is not a particularly inspiring reason to care, but for your funders, it may be a sign that you have your house in order. And finally, number 4, to avoid confusion later on. So here I'll give a bit more detail about the timeline. Earlier, you heard that ONCA took effect on October 19th, 2021. There is a 3-year transition period ending on October 19th, 2024. What happens at the end of this 3-year period? No organization is going to disappear. There aren't going to be any fines or any punishments, so don't worry about that. What's going to happen is, from ONCA's perspective, your rules are going to automatically shift over to be ONCA compliant rules. What that means is not that your documents will magically change. Rather, it will mean that your documents may no longer reflect what your actual rules are from a legal point of view. That's not the end of the world, but it is a confusing situation. So to avoid that confusing situation, consider transitioning to the ONCA sometime before October 19th, 2024. So those are 4 reasons to care. Here are 2 reasons you don't need to worry. Number 1, there are no ONCA police. It's nobody's job in the government to knock on your door and ask you, have you complied with your bylaws? The way ONCA is set up, your members, your directors, your officers have the right to, if they believe your nonprofit is not following the law, take your organization to court. This very rarely happens. And the reason is, 1, most people who are involved with a nonprofit want it to succeed. And nothing hurts a nonprofit quite like going to court. Number two, even for those individuals who do not want your nonprofit to succeed, it's still a lot of time, money, emotional drain on them personally to take you to court. Most people are not that motivated, even if there is something genuinely wrong going on. So for better or worse, the reality is most organizations work out issues with their bylaws or articles outside of court through relationships, through discussion, etc. So ONCA is more of a positive opportunity to improve your governance than something to be worried about. The second reason I don't think people need to worry is that ONCA is not a major overhaul. For those who knew the previous law, Ontario Corporations Act, this law is broadly similar. With that, let's talk about those areas in which there are some bigger differences. The first one is this concept of a public benefit corporation. This is a new concept under the ONCA. Under ONCA, all nonprofits face the same set of rules, but some nonprofits face additional rules. These nonprofits are called public benefit corporations. So the question is, who qualifies as a public benefit corporation, and what are these additional rules? A nonprofit is a public benefit corporation if it is either A, a charity, or B, last year it received more than $10,000 in either grants or financial assistance from government, and that means federal, provincial, municipal, or an agency of government, or gifts or donations from sources other than your members, directors, officers, or employees. Based on how participants answered the pre-session survey, it seems that we have a mix of public benefit corporations and not public benefit corporations in the room. So every organization will have to figure out for itself whether these rules apply. Public benefit corporations face three main additional rules that others don't. There are others, but these are the three big ones. Number one, when an organization dissolves, the question is, who will get its remaining property? By property, I mean money, I mean equipment, I mean real estate, I mean everything. I'm using it in a broad way. So if an organization dissolves, who gets the property? For a regular nonprofit, the answer is anybody in theory. You could write in your bylaws or your articles, anybody gets our property. For a public benefit corporation, it's not that simple. Public benefit corporations can only give their property upon dissolution to either A, government, that means federal, provincial, municipal government, or an agency of government, or B, if the public benefit corporation is a charity, then they can only give it to other registered charities with similar purposes, or C, if the public benefit corporation is not a charity, then they can also give the property to other public benefit corporations with similar purposes. Rule number two, that's different for public benefit corporations. You may be surprised to hear this, but nonprofits in general can have employees sit on the board. In theory, your entire board could be made up exclusively of employees. Again, remember my disclaimer. The law is not the same thing as best practices. Funders may see this as a red flag, as may the public, and so on. But legally speaking, it's possible. And there may be some situations in which it's appropriate. So that's possible for regular nonprofits, unless their governing documents say it's prohibited. For a public benefit corporation, only up to 1/3 of the board can be employees. Now, there are additional rules for charities. If your organization is a charity, not only do you have to follow ONCA, you also have to follow charity law. And charity law says the situations in which someone who's on the board of a charity can be paid as an employee or otherwise are highly, highly limited. Some lawyers simply say it's not allowed. You cannot have employees on the board of a charity. That's not exactly true. It's sometimes allowed, but it's very limited. To learn more about this, see the guide, Payments to Directors and Connected Persons, published by the Ontario Public Guardian and Trustee. The final area where public benefit corporations are different from other nonprofits is they face higher standards of financial review, and we're going to talk about that now. By default, under ONCA, all nonprofits have to get an audit each and every year. But some nonprofits have the ability to pass what's called an extraordinary resolution and waive the audit. And if they do this, they may be required to get a review engagement, or they may not be required to get any external financial review whatsoever. So this raises the question, what's an extraordinary resolution? What's a review engagement, and who has this ability? An extraordinary resolution is a motion passed at a members' meeting that receives 80% or more of the votes cast at that meeting in favor. You can also pass an extraordinary resolution outside of a members' meeting if you get the agreement of everybody who is entitled to vote on the resolution. What's a review engagement? I'll explain a review engagement by contrast to an audit. An audit is where a chartered professional accountant comes in, looks at your source documents, such as your invoices and your receipts, looks at your financial policies, such as your signing authorities, looks at your financial statements, like your balance sheet or your cash flow, and then concludes based on all that whether or not they can provide reasonable assurance that your financial statements are a reliable reflection of your organization's financial position. That's an audit. What's a review engagement? A review engagement is also a chartered professional accountant coming in, looking at your source documents, looking at your financial policies, looking at your financial statement, but it's faster and it's cheaper, and that's because it's less extensive. At the end of the day, the accountant is saying whether or not they believe your financial statements are a plausible reflection of your financial position. What does plausible mean? It just means they didn't see any red flags. This may be appropriate for some organizations with less complicated finances or few external stakeholders. It may not. It's for every organization to decide for itself. Who has this ability to pass an extraordinary resolution and get a review engagement instead? So calling your attention to the table on this slide, for organizations with annual revenue under 100,000, and when I say revenue, I mean everything. I mean your donations, I mean sponsorships, fees for service, etc. It's a broad term. For organizations with annual revenue under 100,000, by default, they need to get an audit each and every year. But each year, they have the option of passing an extraordinary resolution and waiving the audit. And then they don't have to get any external financial review. For organizations with annual revenue between 100,000 and 500,000, by default, they have to get an audit. But each year, they have the ability to pass an extraordinary resolution and waive the audit. For organizations that are public benefit corporations, they must at least get a review engagement. For organizations with annual revenue above $500,000, by default, they have to get an audit. And if they're a public benefit corporation, they have to get an audit, period. The rules have not changed for them. But if they're not a public benefit corporation, they have the ability to pass an extraordinary resolution, waive the audit, but they have to at least get a review engagement instead. Now, at the same time that the ONCA took effect, a new online system went live. This online system is known as the Ontario Business Registry. and it allows nonprofits to do many things. You can order a corporate profile, which is a very good idea for every nonprofit to do. The profile tells you who the government has listed as your current directors, as well as your current address. It also allows nonprofits to file a notice of change. This is something nonprofits are required to do to inform the government if the address, directors, or officers have recently changed. It allows nonprofits to file an annual return, which nonprofits are required to do to tell the government whether or not directors, officers, or the address has changed this past year. It also allows nonprofits to update their articles, something we're going to talk more about later. Nothing in the Ontario Business Registry is a replacement for your filings with the Canada Revenue Agency, the CRA for short. If you are a registered charity, you are still required to file your annual information return, your T3010, with the CRA. Please note there are glitches. So what steps do nonprofits need to take to come into compliance with ONCA? So firstly, figure out whether ONCA applies to you. For those of you who joined a bit late, ONCA applies to nonprofits that are provincially incorporated. It does not apply to nonprofits that are federally incorporated or that are incorporated as co-ops, businesses, condo corporations, or organizations that are not incorporated at all. If you've figured out that ONCA applies to you, the next thing is to figure out when do you need to act. So I mentioned that ONCA took effect on October 19th, 2021, and there is a 3-year period ending on October 19th, 2024. I would like to add a few details. So firstly, during this 3-year period, what are the rules that apply? Well, during this 3-year period, your governing documents, so your articles and your bylaws, as long as they were valid before ONCA took effect, they continue to be valid until October 19th, 2024, even if they contradict ONCA. However, if you're dealing with a situation and your bylaws or articles don't address it, there isn't any rule you can find, now you are looking to ONCA for the answer. So ONCA applies as of October 19th, 2021, but there is a bubble around your governing documents. At the end of the 3-year period, I mentioned that ONCA will consider most of your nonprofit's rules to automatically change over. That implies there are a few exceptions. What are those exceptions? So in a few cases, ONCA says you need to put things in your articles that historically nonprofits would have normally put in their bylaws. For these important rules, ONCA says, look, if they're in your bylaws, that's fine, even past October 19th, 2024. As long as they were in your bylaws before ONCA took effect, they continue to be valid. But if you ever want to make changes to these rules, you're going to have to do so in your articles. It's not enough just to make the changes in your bylaws. So what are these rules? Number 1, the size of your board. Number 2, if you have multiple types of members, what's called member classes, then that information would now need to be put in the articles. Number 3, the voting rights of members. ONCA assumes that it's one member, one vote. If you have a different structure, for example, some people are non-voting members, which is allowed, that information would have to go in the articles. Again, if you have it in the bylaws, that's fine, but going forward, you would need to put it in the articles. And then number 4, a dissolution clause. This is a line that says what happens to your property if your organization dissolves. ONCA wants you to put this in your articles to be effective. In any case, the dissolution clause cannot contradict the rule for public benefit corporations. How long does it actually take to do the work of transitioning to the ONCA? The estimate I've heard from lawyers that work in this area is 6 to 12 months. Here are 4 things that could cause it to take a longer amount of time or a shorter amount of time for your organization. Number 1, the age of your governing documents. If this is the first time you're looking at your governing documents in, let's say, 20 years, 30 years, chances are there are more things that you're going to want to change than just what ONCA requires. That's fine. That's part of the benefit of this process, but it is likely to take longer. Number two, the capacity on your board. Do you have people that feel comfortable with your governing documents, who perhaps have legal experience? Do you have the time? Do you have a shortage of people on your board, etc.? The less capacity you have, the longer it's going to take them to actually get through the process. Number three, consensus. Sometimes the ONCA transition process kicks up the dust on certain controversial issues. There may be disagreements within your board on certain key issues like who is a member or how big the board should be. Or there may be disagreements between your board and the membership or within the membership. Taking the time to build consensus does lead to a longer process. However, if you actually build the consensus, it's more likely that people will perceive the end result as legitimate, and it's more likely they'll actually follow the rules. Remember what I said at the beginning, ONCA compliance is not just about what you put in your documents, it's about how you actually follow them at the end of the day. And number four, the ease of holding members' meetings. If it's hard for you to hold a members' meeting, I mentioned earlier, you need member approval. So you're going to, typically that means you're going to have a members' meeting. If it's hard for you to hold a members' meeting, you may have to wait until the next annual members' meeting. If it's easy, then that can speed up the process. I commonly get a number of questions relating to working with lawyers, so I'll address some of those questions now. Number one, do you need to work with a lawyer? The answer is no. There's no legal requirement that says you have to work with a lawyer, that a lawyer has to approve your bylaws. It can provide value if you're in a situation where you have a lot of assets or there are major disagreements in your organization that makes conflict more likely. So you really want to dot your I's or cross your T's. It can also be more valuable in a situation where there are multiple organizations involved and they all relate to each other. For example, a chapter and a head body, or a multi-corporate structure, a foundation and an organization, etc. The second question I get is what kind of fees to expect. So one Toronto lawyer that specializes in this area wrote a blog post saying that on average, it costs about $5,000 to $15,000. That's quite expensive. That is for a process where the lawyer is taking over everything. What I really want to emphasize is that working with a lawyer is not all or nothing. There are many things that you can do for yourself that will save time, that will save money, and that will ultimately make it more likely that your rules are sensitive to your working situation, that you understand them, and so you're more likely to follow them. What are these things you can do? So number one, you can get your records in order so that the lawyer doesn't have to spend a lot of time just sorting through your records. We're going to talk more about that on the next slide. Number two, by identifying what you need to change or want to change for yourselves and maybe trying to draft some of the changes, that can sometimes cut down on the time the lawyer needs to actually draft the changes. The more you understand about ONCA, the better able you will be to limit the questions you have for a lawyer to only those you really need a lawyer's insight for. Again, you can choose to work with a lawyer or not, but if you do choose to work with a lawyer, I just want to emphasize it's not all or nothing. So I mentioned getting your records in order. For some lawyers, this is the bulk of the work. What records does ONCA say you need to keep? Number one, your letters patent. We talked about this earlier. It's the document the government sent you when you first became incorporated. It includes your purposes, your founding directors, any special provisions you asked for, your founding address, and so on. If you ever made changes to your letters patent in the past, the government wouldn't have sent you a new letters patent. They would have sent you what are called supplementary letters patent, which is basically an addendum. So you have your letters patent, you have your supplementary letters patent, you read them together, and then you understand them. Number two, your bylaws. It's important to know what you're updating. Number 3, your minutes. ONCA says that nonprofits need to keep 4 kinds of minutes. Number 1, members meeting minutes. Number 2, board meeting minutes. Number 3, board committee meeting minutes. And number 4, member committee meeting minutes. These minutes can be kept virtually. You can keep them on Google Drive or the cloud, as long as they are accessible from your headquarters in Ontario or another location designated by the board, with an Ontario for most records. The fourth type of document ONCA wants you to keep are special resolutions. What makes these resolutions so special? They require a 2/3 majority approval. Usually, when something requires a 2/3 majority approval, it's because it's very important, like a change of name for your organization, a change of purposes, something like that. So it's important to know what these say. Number 5, a directors and officers register. A register is a fancy legal word for list. ONCA requires you to keep a register of your directors and your officers going back 6 years, both your current and former directors and officers. The register should include their names, their start date, their end date, their address for service. This means the address where they agreed to receive documents. Doesn't need to be their personal address. And if they agree to receive documents electronically, their email address as well. For officers, the list should also include their title. In addition to directors and officers register, ONCA requires you to keep a register of members. It's important to have a complete list of members because members have all kinds of rights and you need to know who has these rights. It also affects quorum for your meetings and so on. It's a very important list to have. The list needs to contain, going back 6 years, the names, the start date, the end date, the address for service. So again, it doesn't have to be the personal address of every member. It's the address where they agreed to receive documents. And the email address if they agreed to receive documents electronically. ONCA also requires nonprofits to keep director consent forms. What is a director consent form? Well, when an individual becomes a director, it's not enough just to elect them, because then you could elect anybody. You could elect Keanu Reeves to be on your board, and then 4 years later tell them, haha, Keanu, you've been liable the whole time. ONCA says, no, that's not enough. You need to get their consent in writing. The form does not have to be complicated. It just needs to say, I, so-and-so, agree to be a director of such and such organization as of X date, so their start date, the address of the individual, so we know which individual we're talking about, and their signature. If you want, you can add other things to this consent form, but you don't have to. The director needs to sign one consent form at the beginning of all consecutive terms they serve. So if an individual serves a term of 4 years, and then they serve another term of 4 years, and then another term of 4 years, they only need to sign one consent form for all those terms. But if they serve a term of 4 years, and then they say, you know what? I actually hate this. This is no fun. They take a vacation for 3 weeks and they come back and they say, I didn't mean it. I want to be back on the board. And you say, sure. Then they need to sign another consent form because you're starting a new period. ONCA also requires you to know your annual revenue to determine, are we a public benefit corporation? Do we need to get an audit? As I said earlier, make sure the government has the right address on file by ordering a corporate profile. It's important to know Do they have the address that is up to date? Because if you want to gain access to the Ontario Business Registry, you're going to have to order a company key. And to get a company key, they are going to send it to you by mail. The ministry no longer accepts a PO box as an address. You need to give them a physical address. So, what might you actually need to change or want to change in your bylaws? Here are 5 examples. Number 1, previously, the law required that nonprofits have a president and a secretary. That is no longer required, although you are still welcome to have them. Now, you are required to have a chair. That needs to be the title, not co-chair, not chairperson, chair. The chair has to be a director of the board. Other officers, such as secretary, treasurer, and so on, do not have to be directors. It's up to you whether you want to make that a requirement or not. Number 2, I mentioned there are new flexibilities in membership. ONCA now allows corporations to be members of a nonprofit. Why would a nonprofit want to allow a corporation to be a member? Well, it could be a way of getting fundraising. For example, you could have local businesses become members and charge them a fee of membership and so on. Number 3, if you have multiple types of members, ONCA says you are required to specify for each class of member in the bylaws how to join the class, how membership ends, and how to withdraw or transfer between classes. Number 4, ONCA says that members who control 10% of the votes in your organization have the right to go to the board and demand that a members' meeting be held. You cannot make this right harder to exercise. You cannot say, no, it has to be 20% of the votes. You can, however, make this right easier. You can say it needs to be 5% of the votes, for example, or 1%. Anything lower than 10% is fine. Finally, number 5, proxy voting. Proxy voting is where an individual doesn't want to or can't attend a member's meeting, so they appoint somebody else to vote on their behalf. By default, under ONCA, proxy voting is not allowed. If you want to allow proxy voting, you have to actively say so in your bylaws or your articles. And I'll just add, proxy voting is never allowed for board meetings. What might you want to change in your articles? Here are 4 examples. Number 1, the purposes of your organization. ONCA does not require you to change your purposes. However, it may have been so long since you last pulled out your articles that once you do pull them out and actually read your purposes, you say, oh, these are our purposes? We don't do that anymore. Or I can't believe we use that language. That's very outdated. It happens, right? So you may want to change your purposes as a result of this process. If you are a charity, changing your purposes can affect your charitable status, and so it would be important at that point to discuss with a lawyer who's knowledgeable in charity law. Number 2, the number of directors. I mentioned that ONCA requires that the number of directors needs to be specified in the articles. ONCA requires a minimum board of 3, so you need to have at least 3 seats on your board. Something new under ONCA, this wasn't allowed previously, is you can specify a range of seats on your board. You can say 3 to 25. You can say 7 to 11. That's up to you. A range gives you the flexibility to grow and to shrink as your situation changes. Number 3, membership classes and voting rights. We've already discussed this. If you have more than 1 membership class, or if your rules are anything other than 1 member, 1 vote, that would need to be put in the articles. And finally, number 4, restrictions on nonprofits' powers. If you want to restrict your nonprofit's powers, if there's something you'd never want your nonprofit to do, you have to say so in the articles. It's not enough to say it in the bylaws. For example, if you were a land trust, you might say we're never going to sell our land. For that to be legally effective, it would need to be in the articles, not just the bylaws. So what's the actual process to approve these changes once you've made them? What I'm about to describe is a default process. Your governing documents may say a different process, in which case follow that. The one thing you absolutely cannot change is that your members have final say. So what's the default process? Somebody proposes the changes to the board. It could be a committee, it could be a director, it could be a lawyer you're working with. It doesn't matter who it is. Somebody proposes it to the board. The board votes on the changes to the bylaws and the articles. Changes that they make to the bylaws that they vote to approve are effective immediately, or at a later date if the board specified a later date. Those changes are only effective until the next members' meeting. Changes to articles are different. The board does not have the power to change articles. What they're voting for is to propose the changes to the articles to the members. Once the board has approved these changes, then you need membership approval. Typically, this is done at a members' meeting. It could be the annual members' meeting, or it could be a special meeting called for this purpose. Or you can have a written resolution outside of a meeting that's unanimously signed on to by all the members entitled to vote. So what do you need to do in order to have a valid members meeting? Well, firstly, you need to send out notice. The notice needs to be sent out enough in advance. The default under ONCA, if your bylaws say nothing, is 10 days to 50 days in advance. The notice needs to contain sufficient detail to allow your members to form a reasoned opinion about what they're asked to vote on. And the notice needs to be sent individually to each member. It's not enough just to post on Instagram. You need to send it either by email or mail or in person, following whatever your rules are for notice, to each member entitled to receive a copy. In addition to the members, the voting members, the directors and the auditors are also entitled to receive a copy of the notice. Once you've sent out proper notice, at the meeting, you need to have a quorum. Quorum is the minimum number of members required to conduct official business. The default quorum under ONCA is 50% plus one of all your voting members. Now, you may say to me, what? 50% plus one? That's crazy. We can barely get 3 people to come out. Don't worry. This 50% plus one is just a default rule. You can change it in your bylaws or your articles. You can set a lower percentage. You can set a lower number. Regardless of what that number is, you need them to be there in order to have an official meeting. Then you have the vote. To vote on changes to bylaws, unless your bylaws say otherwise, you need 50% plus one of the votes cast at the meeting to be in favor of the changes to the bylaws. Once the members have approved the bylaws, you're done. You're good. They're effective permanently. For the articles, it's a bit different. The members need to pass changes to articles with a 2/3 majority. Once you have passed the changes to the bylaws and the articles, if you're a registered charity, you need to file the bylaws with the Canada Revenue Agency. The CRA does not approve these changes, but they want to have them on record. For the articles, you are now required to file them with the Government of Ontario using one of 3 methods. Number 1, the Ontario Business Registry. To access the Ontario Business Registry, you need 3 things: a company key, a one key, and a Service Ontario account. The ONCA and Service Ontario account you may already have. They're online usernames and passwords. It's for you to create them. They can be created online. The company key needs to be ordered from the government and it's mailed to you. So you need to make sure you have the right address. The second method is by mail. You can go online to the Ontario Forms repository, download a form, fill it out, and mail it in. But even by mail, you need to include your company key. So you still need to order a company key. The third option is working with a third party. There are 2 third parties listed on the Ontario Business Registry website. There are additional fees for working with third parties. Now, if you're ordering a company key, some things to watch out for. It's going to take a little while. I've heard recently 1 to 3 weeks. If you order more than one company key, every subsequent company key is going to cancel the earlier company key. So make sure to only order once and wait for it to come. I'm going to conclude by telling you briefly about some of the resources we have for you. So on the Nonprofit Law Ontario website, there's more information about everything we've discussed here. There is an app that takes you through a series of questions and can actually create a set of bylaws for you. There's a sample set of bylaws with some options for different sections. There is a guide that walks you through the pros and the cons of making different choices. There is a workbook that takes you section by section through the changes in the ONCA and allows you to review your bylaws and say, we need this, we want this. There's a directory of lawyers that work in this area if you want to connect with a lawyer. There's a glossary of terms. And finally, you can email me a question. Thank you very much for listening. I can be reached at this email, and you can find more information at this URL. I would now be happy to take your questions.
Benjamin, there are a couple of questions in the queue.
Hmm?
Do you like me to read them to you?
That's fine. I'll go through them.
Okay, great,
So,
perfect.
yeah. So I'll go through the chat first, then I'll jump to the Q&A, then I'll jump back to the chat. So Jenny asks, do you need to do the extraordinary resolution every year? We have trustees that do an annual review. We did the extraordinary resolution several years ago, and this has become a regular practice. The extraordinary resolution does have to be done every year if you want to waive the audit. If you do not do an extraordinary resolution in a given year, you have to do an audit for that year. Any advice of finding a phone contact with the Ontario Business Registry if our company key does not arrive by mail? Unfortunately, no. It is unfortunate. I've heard of different organizations' struggles with trying to get in touch with Service Ontario. But if you go to the bottom of the Ontario Business Registry webpage, you will find the Service Ontario contact details, and you can also submit a form. Can you please add the email to the chat? Yes, I am adding my email to the chat. I'm now going to move over to the Q&A. If a public benefit corporation dissolves, can it transfer its assets to a federal charity that has the same mandate but is not a registered organization with the Ontario government? If the public benefit corporation is a charity and that federal organization is a charity, the answer is yes. If the public benefit corporation is not a charity, the answer is only if that federal corporation is a registered charity can it transfer it to the registered charity. But if that federal corporation is not a charity, the public benefit corporation cannot transfer the assets to that federal corporation. Regarding audit, is the extraordinary resolution done annually at the AGM for the next year like electing the auditor was? Yes, it's done annually for the next year. Regarding review engagement versus audit, can an organization update its bylaws to state that it can have a review engagement produced annually instead of an audit, so long as the revenues are under 500,000, or is an extraordinary resolution required to be passed every year? Yeah, so it's similar.
Just for the interpreter, if you don't mind reading so fast, please.
I apologize, yes.
Yeah.
Regarding review engagement versus audit, can an organization update its bylaws to state that it can have a review engagement produced annually instead of an audit, so long as revenues are under 500,000? Or is an extraordinary resolution required to be passed every year? So as I mentioned previously, an extraordinary resolution is required to be passed every year. What I would add here is that you can set out in your bylaws that you require the organization to at least do a review engagement, even if it might have the option not to do that. Will filing the review engagement / audit be required with annual filings? No, there's no requirement for nonprofits to file their financial statements. Unless they're a registered charity, then they need to make financial filings with their T3010. How many past years of minute books need to be submitted with ONCA registration? To be clear, when I listed out those records, there is no requirement to submit all those records. Those are the requirements you need to have and to keep to know where they are. To your question, how many years do you need to keep? The answer is, and I hope everybody is sitting down, all of them. That is not realistic for most organizations. And if you don't have minutes, it's not the end of the world. Again, there are no ONCA police. But technically speaking, you do need to keep all your minutes. So don't go shredding minutes, don't go deleting minutes. What is the default in ONCA regarding electronic communications of notice to members? The rule in this area has actually changed recently. By default, you can send electronic notices, unless your governing documents say otherwise. So check your governing documents, but if they say nothing, you can send electronic notices. How do you file bylaws with the CRA? I will drop the link in the chat. Give me a moment. Please see the chat for the link to file your bylaws. Susan asks, does a board-approved audit report need to be presented at the AGM, or can it be a draft report? It must be a board-approved audit report. If we have a separate foundation, do we need to involve them? Each corporation has to do its own transition. So if there are two corporations, each one separately needs to look at its governing documents and transition to ONCA. Now, whether or not each organization needs to involve the other organization in its transition depends on whether its governing documents are affected by the other organization. For example, maybe the directors of one organization are defined as the same number of the directors of the other organization. So if you change the size of the board in one organization, that may have an unintended impact on the other organization. so the two organizations may want to coordinate. Regarding notifying members individually by email, if they have signed on to a group distribution list, can we use that group list for notifications of a meeting, or do we need to email them individually? The idea of individual notification is that the individual needs to have it come to them somehow. It doesn't mean that the email has to be addressed personally to them. It doesn't need to say, "Dear Tom," for example. If they're on a group list and it comes into their inbox, that's fine. It came to them individually. I appreciate you can't give advice, but can you speak generally to the pros and cons of having a definition of member that includes the board of directors, as well as the founding/managing director of the nonprofit, and potentially the artistic director as well? The other options would simply be to have the members be the board. Great question. I'm going to call your attention to a page on the Nonprofit Law Ontario website, and I'm putting the link in the chat. This page goes through different common membership structures and discusses the pros and cons. But I will address your specific question. So the question is, what is the pros and cons of having employees on the board versus just having the board, employees as members versus just having the board as members? So in general, the pro of having just the board be your members is that it's simpler administratively because they're all in communication anyway. And you have less of a risk of disagreements among the members, if only because there are fewer members. Less of a risk of outside interference in the membership and so on. The cons of having your board be the only members is that effectively your board answers to almost nobody. If you have funders, they may answer to the funders, but there is nobody legally who has the power to remove them or to take them to court other than individual directors or officers, or in some cases lenders, for violations of the ONCA. So including anybody else, whether they're employees or not, builds a bit of external accountability for the board. This can get complicated when there are employment law issues. For example, if you want to fire that staff and they have membership powers, they can use those membership powers to act in their own interests. There's nothing that, unless you make a requirement, there's nothing that prevents a member from engaging in a conflict of interest. So these are things to be careful about. You may wish to create a balance of power in order for there to be more accountability between the board and staff, but it may also complicate things administratively. There's no one right answer. We have our purpose and mission statement currently listed in our bylaws. If we made a basic update to our statement using synonymous but more contemporary language to express the same idea, would that necessitate a review by a lawyer? The purposes of the organization that are legally effective are the purposes listed in the articles. Not the bylaws, not the website, not your pamphlet, the articles only. If there is any conflict between the articles and those other documents, the articles win. For a registered charity, the Canada Revenue Agency looks to see that all of the organization's documents, publications, and so on are consistent with what the organization claims its purposes are in the articles. Therefore, if an organization is making changes to any of its publications, then it runs the risk of creating an inconsistency. An organization may therefore wish to speak with a lawyer about whether the language is consistent. Please talk about the potential impact of a corporation becoming a member. For example, would the corporation get one vote as a member, or could the corporation potentially get more votes? Great question. Corporations are like other persons or individuals, meaning each member gets just one vote, unless you say otherwise in your articles. So by default, the corporation has one vote. If you want it to have more, you can make that happen. How does this happen in practice? Well, ahead of a members' meeting, you would perhaps ask the corporation to send you a form appointing somebody who is going to vote on their behalf. They may have more than one representative in the room at the members' meeting. So it's going to be important for you to understand which one of these individuals is empowered to actually cast the vote. That's one of the practical differences. You may choose for a corporation to have more than one vote and come up with your own procedure about how these votes are going to be cast and decided on. Does everyone who might have to file info for the corporation need a separate ONCA account? Would they all use the same company key? They would all use the same company key, for sure, yes. Generally, they would all use the same ONCA. However, if you have a representative, such as a lawyer or an accountant, they may have their own ONCA and enter the system using that. So if filing a review engagement / audit will not be required when you file your annual review, and there is no ONCA police, then is it safe to assume that you can forget to do that if funders don't require it? Wink. Great question. I love the wink. The answer is, if you are legally required to file an audit, but you don't file an audit, or sorry, you don't do an audit, then the risk is that a member, a director, or an officer can take the organization to court and ask that the Superior Court make the organization file the perform the audit. That individual could also demand that a members' meeting be called, could get together with other members to demand a members' meeting be called, and could start a procedure to get a court-appointed auditor. So the answer is, in practice, many organizations don't do an audit and nothing ever happens as a result. But for some organizations, especially if there are internal disputes in the organization, or if something else scandalous happens and all of a sudden the organization is in the media, or one day it applies for funding and that funder asks for past audits, then it can lead to issues to not have those audits in place. So it's a risk rewards calculation. I do know many organizations that haven't gotten audits in decades, and for many of them, I'm sure nothing will come of it. But you know your own situation best. If a separate foundation holds the assets, do you need a dissolution process? ONCA sets out a dissolution process. So there is no requirement for a nonprofit to have its own process set out in its bylaws. You can just rely on the act. If you're asking if an organization has no assets, does it have to bother filing articles of incorporation, for example? The answer is, as long as you don't file articles of incorporation, the last directors who were listed as directors, if they didn't resign, they remain liable. Now, where's the liability if an organization isn't doing anything? You're right, it may be minimal liability, but it's still out there. If they do resign, whoever is the last kind of controlling officer, maybe an employee, maybe a volunteer, that person is left holding the bag. So it's a loose end. There are probably thousands of corporations on the Ontario Business Registry that are not active anymore and never properly dissolved. There are many zombie corporations, you might call them. Again, this is another example of it's a risk-reward calculation, and it's up to you how comfortable you are with those loose ends. If we choose to have officer roles and responsibilities outlined in a board orientation package as opposed to bylaws, would that cause any friction/confusion, or would that be a helpful way to minimize the amount of language or potential revisions of the bylaws? So this is a great question for a number of reasons. Firstly, it highlights that for sections that don't need to be included in the bylaws, you can put them elsewhere. Examples of this are officer job descriptions. There's no requirement to put that in the bylaws. Even what officers you're required to have, although it's typical to have that kind of information in the bylaws, it's enough to simply have a board resolution and the information can be contained elsewhere. So this question helpfully illustrates that you can break up where different information goes. One thing to be careful about, though, is a board resolution does need to be passed in order to appoint officers and to change their job descriptions if the job description was created by a board resolution. So that needs to be clear. And the chair, you're required to have that regardless of what you say. Is there any limitation for voting virtually for a resolution or election of directors required by ONCA? Can voting for directors or bylaw changes happen via platforms in a certain period of time without members being online? Great question. The rules in this area have actually recently changed. By default, ONCA now allows hybrid voting, online voting, remote voting, mail-in ballots, telephone voting, and so on. If your bylaws restrict this, they can, and so be careful to look in your bylaws first. Now, there's two kinds of things to think about when we think about online voting. There's online voting, and then there's online meeting participation. Online voting could, in theory, happen before the meeting happens. It couldn't happen after, but it could happen before. as long as it's counted at the meeting. That's fine, that those votes can count unless your bylaws say otherwise. But votes that aren't taking place at the meeting do not count as those members participating at the meeting. So you cannot count those votes towards your quorum, for example. Remember, quorum is the minimum number of members who are present at the meeting. This could include people who are present virtually or by phone, but they need to be present at that time and be able to communicate back and forth with people in the meeting.
Thank you so much, Benjamin. We have one more question that came up in the chat. And the question is, where can we get more detail on member quorum?
Where can we get more detail on member quorum?
I guess maybe how to set quorum or what should be. I mean, you did mention it in your presentation, but any additional information?
Okay. This is a great opportunity for me to give you a brief tour of the legislation itself so that you are able to search and read the legislation to find answers for yourself. And for that reason, this is a great question. They are, in fact, all great questions, but they're great questions for different reasons. And I do personally enjoy some questions over others. So for those who I didn't say it's a great question to, you should know your questions are also great, but I do personally enjoy some rather than others. But there's always someone in the room for whom that is the greatest question. So thank you to everyone for all the questions you've asked thus far. Okay, here is the Not-for-Profit Corporations Act. The way I found it was by Googling Not-for-Profit Corporations Act, and you'll see the first web page that comes up, ontario.ca/laws. And if you go to that, you can also search Not-for-Profit Corporations Act on its homepage. The first thing you may be thrown off by is the presence of 2010 in the name. You may say, does this mean this is an old version of the Act? No, it just means that it was actually passed in 2010. It took a long time to take effect. This is the current version. You can see versions over here. Okay, let's scroll down and you'll see your friend, the table of contents. This is your best friend in navigating the Act. And one of the nice new things about ONCA is this much clearer table of contents. So we're interested in members meeting quorums. So we're looking at the sections, we're looking at the parts. There's a part called members. Sounds like it might be in there. So I look through the different sections, membership, issuance, and termination, and I go down to quorum for a members meeting, section 57. I click on section 57 and it tells me, unless the bylaws provide otherwise, so I learned from this that I can say something different in my bylaws, the quorum for a meeting of the members is a majority of the members entitled to vote. So that's where I get that 50% plus one language. And it's only 50% plus one of the members entitled to vote, the voting members at the meeting, whether present in person or by proxy. It gives me more information about the quorum, such as if a quorum is present at the beginning of the meeting, but you lose quorum partway through, the meeting can continue. That's new under the ONCA. It's not a detail we got into. You can change that in your bylaws. So if you want to read the Act, that's the way to do it. In this case, it was helpfully in the table of contents, but if it wasn't in the table of contents, I would go to an area where it sounded relevant and just scroll up and down and just explore a bit. If you want to look on our website where to find this kind of information, go under Run a Nonprofit, and there's a page called Meetings, and you can learn more about meetings there.
Great. Thank you so much, Benjamin. I've attended your sessions in the past, and each time I learn something new. So it's really, really great. And we really appreciate that. I want to also take some time to thank our ASL interpreters, Dean and Emma, today. You were fabulous. And I also want to thank the Toronto Arts Foundation team behind the scenes, making this all possible. And thank you all to the network members and new guests who are joining us today on this topic. There will be a survey that will be sent out. Please complete it. It helps us and also helps Benjamin with developing these sessions for future groups. Also to add before we end off for the day is our next session is on November 22nd, where Against the Grain Theatre will present their governance case for examination, exploration, and learning. Thank you again. Thank you, Benjamin, again, if there's any final words.
Yes. So firstly, I also want to thank the ASL interpreters. This was my first time working with them. So I apologize if at any time I was too fast. And I hope it was clear to everyone. Secondly, I want to wish everybody a good process. I hope your organizations come out of it stronger. And thank you everyone again for your questions and for your time and attention. Have a great day, everyone.
Thank you, everyone. Bye-bye.